the final thing that I want to talk to you about is maintenance, both spousal and child maintenance. It's probably the most common question that we receive, and receive touched on the court's consideration of a clean break.
Yeah.
But in the cases, if we touch on spousal maintenance first, and somebody's inability to work and being very dependent on benefits, what is your position and what would be your advice there?
Well, I think, as I say, in these sorts of cases, clean breaks are just not going to work, unfortunately. And that will be difficult for the non-resident parent. But as I say, hopefully that is a matter which they will accept. But you have to be, as I say, you've got to look at needs very broadly in these sorts of cases. And we've seen that, in fairness, raised time and time again by the higher courts when they've given judgments in these cases. You've got to think outside the box. So if this is a case where there's a requirement for respite care or adaptations to properties, or as I say, if there's the need for additional help and the
Yes.
costs of that additional help, if it's live-in help, are you looking at larger accommodation? There have even been cases where the court has said it's appropriate to look at the costs of feeding the additional help. So as I say, it's all those running costs that you have to think about, which are outside of the norm or the traditional approach that one would see in a case where you have children without special educational needs, because it all comes back to the first consideration has to be the welfare of any minor, and that has to be considered when you're looking at spousal maintenance in these cases. There's also additional provision. For example, we have exceptional provision of education in pupil referral units or elsewhere. That is a provision which in these sorts of cases, you have to bear in mind. It's particularly useful where you have a parent who'd like to be able to work, but is unable to do so
Yeah.
because the child not being in education, or a party who seeks their former partner's assertion that they cannot work.
Yeah.
So you can look more broadly. Do local authorities, for example, have what they call a local offer under the Children and Families Act 2014? So what services are available locally for children and young people and families within the locality? And all I would say about that is that it's a very helpful statutory provision, which you can look at when you're looking at the broad spectrum of maintenance and financial supports in these sorts of cases. But as we know, with pressures on budget and cost of living crisis, local authorities are having to cut back. But there is still provision there. And as I say, it's something which has to be borne in mind.
As you know, a lot of the time, the resident parent will be very dependent on benefits, which are unlikely to meet all of their needs. So, would you say in the majority of these cases, it is more likely that will be a substantive spousal maintenance order
Oh,
of?
most definitely. And indeed, courts in previous cases have, in some respects, been quite critical and have said that when one takes into account benefits, that's more of a discretionary exercise. For example, if you're looking at where parties have not been married and you're looking at what we call a Schedule 1 Act claim for maintenance, the higher courts have said that it's only a discretion to take into account benefits, and that shouldn't be, as it were, a pound for pound deduction from what is an appropriate standard of living, and that the court has to look very broadly at what the needs are.
I'm always very concerned about the suggestion of a clean break. In fact, I advise against it when you have a child. Needs evolve. And essentially, you could be in a position whereby a lot of the child related benefits that they're receiving when they end, you have a party who hasn't worked for many, many years, may need to retrain. That's a really difficult position for someone to find themselves in, isn't it?
Hugely so. And also, I've had cases recently where, for example, parties that had been reliant on specific supports from local authorities to help with educational provision, which were then withdrawn because the funding was no longer there. And it reverted back and fell upon the shoulders of the primary carer, who had to reduce hours substantially in order to support the child because the educational support was no longer there. And these are the things that you have to think of, because they are more likely in these
Yeah.
sorts of cases where you are so heavily reliant upon supports from a number of sources. And that has to be borne in mind when you are considering a clean break. And I entirely agree. These cases are not appropriate for clean breaks in my experience, the cases I see.
In relation to what we call I don't want to get too technical, but the nominal maintenance order, which is basically a safety net for the future, do you think they're more appropriate in these cases? I mean, arguably, I've never actually had an application to make a nominal maintenance order a substantive order, but would you say there's more of a room for that in these cases?
I often find in the majority of cases that I deal with children with special educational needs, you're looking at a substantive order in any event. So it's more than a nominal order. But a nominal order is the bare minimum, in my view, in these sorts of cases. I agree. I think in over 20, 25 years, I could count on one hand the number of cases where I've had nominal orders converted into a substantive order in these sorts of cases. But they're an important safety net, which I think is really important in these cases. But as I say, in my experience, one tends to be looking at substantive orders in these
So
cases.
that means an amount per month of
Yeah,
spousal
yeah.
maintenance to the resident
Which
parent.
above and beyond, because the nominal is usually expressed as 5p per annum. And one is
Okay.
looking at a much more significant monthly payment.
Absolutely. And that brings me on to child maintenance, and then I want to loop back to just maintenance generally. So for child maintenance, what many parents would be concerned about is that come 18, what's going to happen when it's not payable? Is there any consideration for extending those payments if you have a child with a serious disability? And I mean that physically or mentally or neurodiverse need.
Put simply, yes. What one can also, in particular, as a good example, as we were discussing before, Schedule 1 of the Children Act, you have the Child Support Act 1991 is where the key piece of legislation which deals with child maintenance in England and Wales. And their financial support has gone beyond initially the 16th birthday and extended through to 19. And judges have said previously that whilst until a child is 19, as it were, the system is governed by the Child Support Act 1991. So that's the prevailing act up until that
But
stage.
if I
But
stop you there, just to make it clear, so up until a child is 19, if there is issues relating to child maintenance, the child maintenance service will deal with that rather than the courts.
yes, but then thereafter, the court has a reserved jurisdiction, particularly where you have, as it were, a significant health need. So, for example, which would cover these sorts of cases, because once you're outside of that limit set by the Child Support Act, then the courts have taken the view that the Children Act is, as it were, isn't restricted or is unfettered by the Child Support Act. But it is limited to exceptions regarding disability. But as I say, that there is provision which will allow for extended child maintenance provision in those circumstances.
But if you have a child who's neurodiverse or has any other form of mental illness, then those are the provisions you can potentially
Yes.
maintenance extended beyond that time because we're a real worry for the resident parent because children don't magically turn a certain age and are no longer reliant. And in these sorts of cases, that dependence, reliance, and the way it restricts the resident parent long term is quite significant, isn't it?
Yes, and also one often finds that, for example, they don't follow the traditional educational path such that by 18 they've completed their secondary education and they may be looking at going off to university. Quite often in these sorts of cases, it takes children longer because of the nature of their educational setting. So they may be in a full-time educational setting for significantly longer, which in itself will delay that transition through to adult supported services which will be available later on. So there is an increased need for maintenance over a significantly longer period of time.
So, if you were dealing with a child who was younger, then would your best advice be to secure some form of spousal maintenance order so that in the event that the benefits or financial support for the child was not sufficient, that the resident parent has that ability to go back to the court and secure some financial provision in the future?
Absolutely. It's vitally important in these sorts of cases because the difficulty is you never know what's coming around the corner.
Absolutely.
And the support will change over time. The needs of the child will change over time. They may increase, not merely decrease, and can often have a devastating impact on these cases that support services that are there can be withdrawn. And that can
Yes,
have a
absolutely.
huge impact on a primary carer with a child with special educational needs.
And being out of the workplace for that extended period of time, the resident parent really has to be given time to be able to retrain and to be able to make their own arrangements to enter the workplace, even if it's on a part-time basis.
Absolutely. It's important that they, in light of the intensive support that they will have provided over many years, are given that, as it were, stage transition to ensure that they can adapt to what is effectively a delayed ending of their support as a primary carer. Whereas parents would normally expect with children who don't have special educational needs, as I said, once they finish their secondary school education and they're off into university, the opportunity to increase working hours or to retrain is available. That is often delayed significantly in cases where you have children with special educational needs, because as I indicated before, their engagement in education is usually over a longer period. And then quite often it will take a significant amount of time to transition from that to supported adult services as well.
Well, Andrew, thank you so much. There's a lot to discuss, but it's an interesting and such an important area of law. And I think both of us are just experiencing so many more cases that have these considerations. So thank you very much for your time today.
Pleasure. Thank you, Rita. Bye bye.
Thank you.